after such a heavy lunch. But our next presenter is very engaging. He's Mr. Charles Leacock, who's the Director of Public Prosecutions in Barbados, which means he knows the law very well. He's also been involved in the OAS processes with respect to cybercrime and cybersecurity. As you know, or you may know, that OAS has a unit that focuses on terrorism and counterterrorism, and within that unit is where they deal with cybercrime, cybersecurity. And through a process, REMJA, the Ministers of Justice and Attorneys General, Mr. Leacock participates in the OAS process and updates them with respect to Barbados' legislation and cybercrime and cybersecurity. So he's a very engaging presenter, and I'm sure he will keep you awake. And with that, I invite Mr. Charles Leacock to the podium to tell us about internet law in Barbados. Please welcome him.
Thanks very much, Rodney. You're always very generous. Very good afternoon to you all. It's always a delight to be able to share some ideas with you, and especially out of the normal murders, rapes, and robberies. This is a welcome break. Internet law has certainly been with us with the advent of the internet, and we heard all about it last night with the development of software like Archie and the ballooning of the internet that has now become almost ungovernable. Within our sphere of operations, we must have rules. Criminal law, being territorial in nature, cannot really confine the internet, which is transnational, transboundary, and genuinely globalized in every simple respect. So today, within this hour, I propose to do a short canter, hopefully informative canter through the internet law of Barbados, generally, but specifically with reference to Barbados, so that we can highlight some of the salient features that we will touch on. So before we get any further, who wants to give me a definition of what is internet crime? Anybody? This side. How would you, if somebody asked you at a conference or cocktail party, how you define internet crime, what would you say? Anybody this side? Obviously, the lunch has been very engaging, so let's go. All right, the definition generally is any abuse of a computer system or computer-related systems for other ends. The other ends refer to largely financial, but not exclusively. Financial is merely illustrative of the other ends. The other ends could be for terrorist purposes or sometimes for purely altruistic reasons, like when we come to discuss the hacktivists and those who hack for the purposes of ensuring your system is good. So it's usually the abuse of computer systems with a motive in mind, and usually in most cases it's financial motive. Now, there are two methods by which we seek to contain internet cybercrimes on the internet, and the two methods are basically by encryption or preventing access to your computers. That's the way by which those are two very broad parameters that are used. You seek to encrypt the information, makes it difficult to access, to alter, to change, and above all, you seek to prevent intruders gaining access to your computer software and computer systems. In Barbados, there's widespread use of the internet. A very small, well-covered jurisdiction with 4G technology. And so we have approximately, according to the government's portal, about 80% of coverage. And we can know so many of us have, so many households have so many phones that connect to the internet, iPads, mini pads, and all the pads. So with that in mind, in Barbados, for a small society, we've done really well within the short time to have coverage as compared to many other societies. But that capability has also allowed for the much development, much facilitation. No longer do you necessarily have to stand in line. You bank online for those people who use it, and invariably you pay your bills. Nobody now goes up to pay a utility bill. You pay it by the click of a mouse from your home. Those are some of the comforts that are brought by the internet, but then, like every system that is susceptible to great use, it's also susceptible to massive misuse. And today that is what we hope to focus on. With respect to, before we get to abuse, Public information is also provided in some respects through the government portal at telecoms.com, which seeks to raise public awareness and to ensure that persons are aware. If you choose to check, you can be informed reasonably well through the websites. And almost every company in Barbados has an internet presence, one way or the other, by which you can contact them, by which they can sell their products, or by which you can see the nature and extent of their products. So we have moved a long way within the last 2 decades of the internet being widespread to almost being commonplace here in Barbados. Now, what's the legal infrastructure for the internet law in Barbados? There are several bits of legislation that governs the use of the internet here in Barbados. The principal piece of legislation is the Computer Misuse Act, Chapter 124B. That has been with us for quite some time. The other piece of legislation that's largely used is the Electronics Transaction Act. That's Chapter 308. That makes legal and admissible in evidence electronic records. Of course, there are exceptions to that. Would anybody wish to tell me what are the exceptions? In which case you must have a piece of paper to conduct a business? Very good. Who is that? I didn't see you. Very. Wills, deeds, and trusts. Those are the 3 exceptions under the Electronic Transactions Act. But most other transactions, electronic records are admissible in court and can prove the existence of a contract, for example. Well, contracts generally can be parole in nature. They need not be reduced to writing. But wills, deeds, and conveyances, those must be evidenced by documents or by writing. So do remember that. Those are the exceptions. Now, also, the Telecommunications Act provides some infrastructure, general for framework for the use of the internet in Barbados, but that's more from a technical point of view. And the Copyright Act, which relates to it, which implements Barbados's obligations under the United Nations, the TRIPS legislation, also has provisions for some aspects of internet and internet-related transactions. Now, the most modern piece of legislation was the Corporate Miscellaneous Provisions Act of 2015, and that allows for the admissibility of a number of electronic records, enhancing and embellishing the regime that already exists under the Electronic Transactions Act. And of course, we have had a draft data protection bill for some time now, which would also address internet and internet-related matters of a personal nature. But that is not law. That's still a bill in stage, and I don't even think it has gotten to the floor of Parliament yet, or has had its first reading. So that's still in draft form as far as I know, and that will await maybe. We have to put it euphemistically, that is still receiving public attention or public comment. Now, the international instruments, Barbados' legislation has been inspired largely by lots of international developments. And one of the first was the efforts by the United Nations since 1990 to address the whole issue of cybercrime. And the Council of Europe in 2000 agreed on the Budapest Convention, or the Convention on Cybercrimes. That has become the international standard on cybercrime legislation. So most legislation around the world is modeled in some form or fashion on the Budapest Convention of 2001. One of the major criticisms, however, of the Budapest Convention is that although it allows for accession by several countries, it was only originally drafted by 47 member states who formed almost an exclusive club. And for any amendments to the Budapest Convention, those 47 members, even if the recommendation comes outside of it, must agree to the amendments. So that has led to one of the major criticisms of the Budapest Convention is that it is not regarded by many countries who were not invited to participate in its deliberations as a truly global standard or instrument because they never had a stake in it. But apart from that, it's quite a good instrument that has inspired much of the legislation around the world. as a result of the Budapest Convention, the Commonwealth, the 53-nation grouping, decided that they must do something because most of the Commonwealth countries were not invited to participate in the drafting of the Budapest Convention. And so the Commonwealth set up a group of experts, and they produced a model bill largely modeled on the Budapest Convention. And that became the standard that is implemented in most Commonwealth countries like Barbados and the Anglophone Caribbean. So we do have features of the substantive features of the Budapest Convention, but through the Commonwealth model. Of course, the Commonwealth model avoids the need for 1,272 bilateral treaties, because if you multiply 53 by 53, you should get somewhere around that, if each country has to sign a treaty with every other country. So that's why the Commonwealth, or large member groupings like the OAS, have used the system of a model treaty so that all member states would be able to discuss it and use it by implementing it to have uniform standards and a uniform approach to address matters of common interest. And of course, as Rodney indicated earlier, the OAS through the REMJA Secretariat and now the Secretariat for Multidimensional Security has the remit to do cybercrime. So all of the international groupings and the multinational entities have focused on cybercrimes. It has been on the agenda of the G8 or the G7 or the G20, whichever configuration you wish at various times, to address cybercrimes, because it has been one of the most pivotal and pervasive issues of our modern times. Now, if I may just briefly touch on what are some of the offenses under the Computer Misuse Act in Barbados. I've listed them there for you, illegal access and all the others. I'm not going to read that, but you can see those for yourselves. And those address, these offenses are offenses that address largely the integrity of the computer systems. Illegal access, interfering with data on the computer, interfering with computer systems. Those are offenses that seek, from a policy point of view, to address the integrity, the confidentiality of computers and the computer systems, so that if the Department of Public Prosecutions were to be hacked, for example, we will use one of these offenses, because it will be, the person will be seeking to interfere or accessing our information, even if they don't change any of the data. The mere fact of illegally accessing the system is an offense, and there are various other offenses that are listed there. Those address the wide panoply of offending that is criminalized under the Budapest Convention, as included in the draft Commonwealth model and implemented in the domestic legislation of Barbados and much of the Anglophone Caribbean. The policy behind the legislation, I've just highlighted this, is to show you what it is. The legislation can briefly be described as in three parts, namely the introduction, the offenses part, and the procedural powers. And it all sets out what part 1 does, what part 2 does, addresses the confidentiality and integrity and availability of information, of data, and while part 3 will address other things like procedural powers and related matters. Now, one of the major offenses also under the Computer Misuse Act, as well as that has emerged with the Internet, is that the Internet has certainly made access to information just at the click of a mouse. I unashamedly tell you, I don't use a library anymore. Whatever research I do, and I do quite a lot, I simply sit at my desk, I never move, because it's all right there at the click of a mouse or a tap on the iPad and tells me exactly what I want, where I want, whatever law from New Zealand or anything I want to look at. You don't have to get up anymore. It's not necessarily good for your exercise, but it certainly is very, very useful from the point of view of how it has revolutionized the way we do business and the way we conduct matters. So one of the offenses that has emerged that has received universal condemnation is the whole offense of child pornography. And Section 23 of the Misuse of Computer Act criminalizes that with a penalty of $50,000 or 5 years imprisonment. Now, would an image, a pseudo-image of a child be an offense? Let's say you have a magazine, what you call them again? Anyhow, like Penthouse or anything like that. If you have not an image of a real child, but an image of a child a morphed image, would that be a criminal offense? Anybody's guess? It's not a real child, but it's the body of a child, but it's not real. Would that be an offense? But I thought the answer is in front of you. It is an offense. Whether it's a real image or a morphed image or a pseudo image, it's all. Because the difference, there are very good reasons for that. Under the standards of the International Association of Prosecutors, they set out a number of reasons why that has to be an offense. Because it's so difficult to decipher, or take it in the general area of criminal law. You can be convicted of aggravated burglary or robbery by the use of an imitation gun. Why? Because it puts the offender householder in as much terror or fear as if it were a real gun, and that person, the complainant or the victim, wouldn't actually know that that's an imitation gun. And some of those imitation toy guns really look very real. So it's the same concept. Whether it's a morphed image or a pseudo image, there's no distinction. Once it's an image, because it tends to give the children the idea that this is acceptable or this is normal conduct for children to be involved in. And that's one of the ratios why morphed images are also criminalized equally as if it were a real image. Now, explicit sexual conduct would always be prohibited as well, and there is also the Protection of Children Act, under which the press has been charged with this and several other people for publishing obscene or indecent photographs of young persons. And young persons are defined very broadly there as persons under the age of 18. So child pornography has been criminalized, and the legislation has been used on several occasions, maybe not with the level of frequency that some members of society would like, but like everything else, you can only prosecute when there is sufficient evidence for a realistic prospect of conviction, and so that is the basis on which that is used. But more topically, you have, in addition to child pornography, you have other offenses under the Act. You have the malicious communications offense. This is under Section 14 of the Computer Misuse Act, and this requires sending of correspondence, letters, or electronic communications to anyone that's indecent or obscene. So you can be charged under this too, that's threatening or that's menacing in character or intending to cause the person annoyance, inconvenience, distress, and all of that. And you're liable on conviction of $10,000 fine or 12 months imprisonment. Now, let us do a little bit of discussion here. Scenario. A person, to be politically correct. A person issues an email, a blast email, to all his friends and the members of the public saying that 200 persons have been killed by a tsunami in Asia. Would that constitute an offense under this? Would that constitute, in your view, malicious communications as the way it is defined there? Anybody on that side?
Is it true or not?
It's not true. But that doesn't answer my question. My question is, would a blast email like that, truth or not, is not important for this purpose. Once an email like that is sent, the members of the public will see it or have access to it. Would that, in your opinion, constitute an offense? Yes. It does cause distress. And those who said yes are quite right, because that actually happened in England. A gentleman issued a blast email saying that hundreds of people were killed in an Asian tsunami, and he was jailed for about 6 months because it caused much public discomfort and disquiet. Or, sorry.
So you're saying that even if it's factual, it's still an offense?
If it's factual, the issue is the sending of the email. The content of the email for this purpose is not. If it's factual, the accused will have a defense of justification that it's true. But if it's false, which would most likely be the case, the question is, does it cause menace or distress to people? And that's why that was criminal. Yes, sir.
So what is the difference between that email and making a report to the news? Saying that 100 people died in the tsunami?
Well, is it fact? If it's true, if they report in the news is factual, well, there's no criminality because they're reporting on an actuality. The only issue arises is when it's false. Okay?
So if it's true and you send it out,
That's fine. You're just repeating an actual fact. Even if the quality varies. Let's say you say hundreds of people die, like the recent fire in Grenville Tower. If you say hundreds of people die in a fire in Notting Hill in England, I mean, it's not hundreds die, you're just embellishing it. But at the end of the day, about, 80 people die or 79 people die. It's factual. Lots of people died. Okay?
Sir.
Sorry.
We just want to remind everybody your interventions to use the microphone, please, so that our people following online can hear. Thank you.
Question, sir. In relation to,
Oh, sorry.
Right.
Sorry. Yeah.
not small guy, but
No. You were standing. Sorry.
I'm wondering if the thought process that goes into it doesn't count, because I can see where it be false, okay, and some person say not necessarily being malicious because they themselves act upon information that was wrong, that was false, that was in itself was false. So whereas I send it out, I overhear a conversation, right? And we live in a WhatsApp community now where people jump the gun. They're not news agencies themselves. So therefore, you overhear something, pick it up in a way that, is not vetted, but you run with it.
Yeah.
Okay, and it becomes false
Yes.
because you didn't do due diligence.
Well, yes, you will have a defense to say, obviously, I'm reposting some or retweeting something that is false. So even if it were to be held that this thing is such a serious nature that caused public consternation and distress and is menacing, and you'd be liable, you're still liable even in defamation law if you repeat a libel. For example, if something is said on the floor of Parliament, it's absolutely privilege. So if a politician says, this man killed his wife, you can't be sued if that's said on the floor of Parliament. If a newspaper publishes that, and that is not true, he can sue. So the mere repetition of something can still result in liability. That's the point I'm making. I'm just drawing an everyday example so you can see. So you'll may be able to mitigate your culpability if it comes to that. All right. Oh, sorry, sir.
No? Oh, okay, great.
All right. Next scenario. The factual matrix was false, but a man issues another email blast to say there was a terrible accident in the United States, a car accident. Well, not terrible. 2 persons died. It's terrible, yes. But he then issued a blast email to say that as a result of this accident, he is going to shoot 200 school children in the United States the next day. He threatened a mass shooting. As a result of that, 3,000 school children in the county of Warren in Tennessee had stayed home by their parents because they were so terrified. Is that criminal or not? All right, well, that one was simple. That goes without saying, because the amount of distress and consternation that caused, that was that. Now, the problem is, how do you balance this? Because the press or the tweeters have the right to free speech. How do you balance this? Because the right to tweet or the right to publish things compared to whether or not it's criminal. Now, the balance has to be struck, and this has been reviewed by several Strasbourg decisions, between whether or not the information provides any great public, is of any great public interest. So, for example, the public or a certain readership's thirst for certain sensational reporting is not protected under that free speech. That is a blunt way of putting it. The courts have held quite clearly that the desire of the public for sensationalism and to always finding out what's going on in your neighbor's bedroom is none of your business, basically. And therefore, the media in publishing things of that nature will not be protected, and so they will be liable for prosecution. As for example, you have the case of the former newspaper that was called in the pejorative the something of the world, the news of the world, but you will call it something else, I'm sure. Because all their stories related to who was having sex with whom. So at the end of the day, they were involved in lots of hacking. And so one of the cases coming out of that is this is how the English court described that. It said, expressed the view that a court is called for when measures taken by a national authority are capable of discouraging the participation of the press in debates over matters of legitimate public concern. That rule could not properly be invoked by a media defendant which is engaged in persistent, pervasive, and flagrant hacking and blagging, and where the information which that would be expected to and did reveal lacked any public significance. So it's always a balance between whether the media is used as a genuine watchdog to promote public discussion on a matter of national importance, or whether it is purely for profit, for voyeurism, or for sensationalism. And that is not a question I can answer in every case. You have to review the facts of each case as they arise. Now, a number of Strasbourg decisions, because the world has become so uniform now with law that the European Court of Human Rights receives great deference in most parts of the world, and even here. And so you have the case of Handyside, which sought to address this balance since in 1976. When it addressed, this gentleman, Handyside, had bought from a Scandinavian publisher something that he called in the English language the Little Red Book, the Little Red School Book, which had lots of sex stories about children. But the morality of 1976, which was what, 40 years ago, is different from the morality of today. If this were to happen today, I don't know if anybody would be even charged or it would be considered. But in 1976, he was charged, and it went before the court. And the European Commission of Human Rights, it didn't have the court then for Britain, said that the information, sorry, went too fast. Yes, it said the freedom of expression applied not only to information and ideas that were favorably received and regarded as inoffensive or indifferent, but equally to those that offend, shock, or disturb the state or any sector of the population. So freedom of information applies also to information that might be considered shocking or offensive. But there is also still the border, where does it cross? And that is determined by every fact situation. All right, if we move off from freedom of information, let us look now at more general cyber issues. Cyber abuse ideas, as you know, I don't want to get too much into this kind of technical stuff, but cyber abuse ideas there are various forms of attacks, basically two forms of attacks. There are semantic attacks involving changing, alteration, and publication of correct and incorrect information in documents, and those require the manipulation and changing of information of the victim or the person who is intruded. Changing perceptions are key to such intrusions, and you seek to destabilize, the intruder seeks to operations of the intruded. Syntactic attacks are different, and these are used through malware, through worms, trojans, horses, and all the others. And this is where you penetrate or illegally access somebody's computer, and you might remain in the system dormantly for a long time. Or you might go in and be so belligerent, you weaponize the information and use it against the person. Now, what's one of the best recent examples of one of these malware attacks? I can't hear you. What? Run. Okay. Well, there are several, but the one I like is the alleged North Korean attack of Sony because of the movie, The Interview. Now, that was an interesting one, because I don't think it has been really disputed that they were the culprits, because they were actually sanctioned. But they, in that case, the allegations are that the North Koreans were able to penetrate Sony's system and actually, I've gone ahead of myself there. Yeah, they were actually able to penetrate Sony's system, install wiper software on the system, and remain in their computers for a very long time. And they then were able to, when they were displeased with the publication of when the movie actually came out, the interview, they then released all the salary scales of the Sony's executive, the bonuses, the intercompany emails, and they stole over 100 terabytes of information. That was massive. And they also released films that Sony had not actually released. So that was very, very damaging, and you can tell the effects that also had on Sony's price stock and all the other consequences that flow from that. So those are some of the things that follow from these hacks that succeed. Now, effects of cyber attacks can be quite distressing. Usually they affect your service. Most of them seek to deny your service, but as I said, some of them can just remain dormant in your system, like the fancy bears, the so-called Russian hackers. I'm just saying this from open sources. I have not actual proof of this, but I'm just saying this from open sources. The so-called fancy bears that have penetrated the systems and remain in their dormant malware, monitoring all that you're doing, and then eventually when they're activated, then they can do whatever damage they wish, deny you service, manipulate your information, and basically destroy. Sure. No, you just stop me anytime.
Hey, good afternoon. Was wondering, is there a mechanism in place to review the act periodically? Or do we follow a particular convention, or are there working groups? Because we went through a few scenarios earlier, and we came to the common conclusion that the act is perhaps deliberately vague, but technology also changes so rapidly. What do we do in Barbados to ensure that we cover our bases?
Yeah, well, very good question, and the answer suggests itself. You said it. Technology changes extremely rapidly, especially internet technology. And as I said, this act that we are using is based on the Budapest Convention of 2001. So that's what, about 16 years ago. Much has changed since then. And so there is always a need to have a dynamic approach to these things. So if, for example, you are aware that there is any shortcoming within the system that ought to be addressed, you should write to the you can either write to the Chief Parliamentary Council or write through your ministry, if you're a ministry, or if you're a private enterprise, you write to the Attorney General, drawing to his attention this deficiency. And from that point of view, they will then refer it to the Law Commission, who will then look at it. Even more so if you have an idea as to how it can be addressed, if you're aware of how it can be. Because when you submit a deficiency, they'll have to look to see how another place has addressed it, because you don't normally go inventing the wheel. So they will look and see how somebody else has addressed that same sort of issue. So if you also know a possible means of redressing it, please include that also. But you can always write to the Attorney General and ask that this matter be looked at. And that is what triggered. I'm confident also you should be able to write, because in Barbados the responsibility for this kind of internet rests with the telecommunications department. So you can also write to them, contact them through their public portal, and they will also forward it to the Attorney General for consideration. You want to say something? Oh, sorry.
I wondered if the communication of that nature to the Attorney General is public. So if I write to the Attorney General in my capacity as a private citizen or my organization, is that public knowledge?
He's not going to say that you wrote to him. He is going to say we have received a request that there are deficiencies in this. You do it with respect to anything, any aspect of criminal law or anything you think should be addressed, and you write, and nobody discloses who, unless you wished it to be disclosed. But he is not good. The authorities are not going to disclose that this person wrote to them about it.
So the other side now is, if I wanted to know whether there was communication saying that there was a deficiency, for instance, in the Computer Misuse Act, could I ask for that information? Could I say, have there been
We do not in Barbados as yet have what we call a Freedom of Information Act. But there's nothing wrong with you, if you wish to know it from respect to a criminal law point of view, nothing wrong if you ask the Commissioner of Police and they will tell you if they're so disposed of. Depends on the purpose for which you want it. If you want it for research or for a public lecture or something like that, I'm sure they'll be happy to make it available to you.
Thank you.
Whatever we prosecute in court, I can tell you because they're all public records. All right. Just a minute. Lost my screen. Good. Right. Now, who are the actors and what are the actions involved in the internet and cybercrimes? You have the actors are usually states, and although they accuse North Korea of doing the Sony hack, every state almost hacks each other. You're hearing on the news every day about the Russian probe, the other side, who apparently were, they also do lots of hacking too. So, I mean, the only problem with it is that if you're caught. So when the Russians were allegedly caught under the last administration in the United States, President Obama expelled a number of them, of 20-something or something like that. So it's whoever is caught, then you're punished. But that doesn't mean that everybody doesn't do it. Then you can have proxies doing hacks, terrorists do hacks, and the hacktivists. You know what are hacktivists? Right, hacktivists, these are the guys who, you can actually pay them to keep hacking to hack your company to see how secure the system is. So, I mean, and these are the good guys, so to speak. So they will check the vulnerabilities of your system, or in fact, some companies actually would pay you if you hack into their system and draw it to their attention so they can put a patch and to cure the defect. Because when a program is written, as you know more about this technical stuff than I do. When you have to patch the system, I mean, you had breaches with Internet Explorer, you had breaches with several bits of software, and in that way, companies are happy to pay you to correct their system because you're helping them avoid a myriad of problems down the road. So you have that, criminals hack and everything. Now, operations would include seeking to get intelligence, shaping cognition, especially through the social media, how you change perceptions, how you change people's outlook of themselves and of their companies' profiles and all of that. And you use hacking for the purposes of crime and for cyber attacks. But I'm sure you will deal more about that as you go on. International example, I've just given you that one with the Sony. And now, what are the challenges? Since we're talking about the reform, and what are the challenges with the internet law in Barbados? I've highlighted some here. This list is by no means exhaustive, but you might find that you can add to. Understanding and shaping cognition, and that's by using social media. You have this whole concept of radicalization, people being radicalized to commit offenses. And that's done by state or non-state actors. You have the targeting of populations through any agency that you may. Many countries lack adequate legislation and executive policies on cybercrime. In as much as we have our laws, as you rightly pointed out, is in need of review constantly because the internet is so dynamic and interactive that one can never be up to date with the actualities and realities in this part of the world. And the need to encourage businesses to invest in cybercrime. I think this is one of the challenges because many times you take it for granted. But when you look at the price, for example, that Sony paid for that hack, whether it's by North Korea or whoever, it's a very, very serious matter. The company's shares plunged and heads were rolled, and there is a serious price to pay. So it is within the interest of companies or personal self-interest to address your internet security and to invest, just like how you put a line item in your budget, less like how you cater for physical security. Now, these days, nobody robs a bank by going into a bank with a gun. That's archaic. You rob a bank now by hacking into the system and you're stealing the money through cyber thefts. I mean, if you have now a bank robbery, it's almost comical. Well, I shouldn't say that. But nobody goes into a bank now with a gun, usually. But you steal far more money through the cyber. And the need, the recruit and maintain cybersecurity staff is also important for companies. And the managing information, all three, volume, velocity, and variety in the public interest is very important. But I'm sure there are tons of other speakers during this two-day forum that will certainly address all those issues for you. I just thought I'd just touch on those kinds of things in passing. Now, what are the major cyber threats? As a country, we have to address cyber threats to all of our infrastructure. And our infrastructure is almost everything. Our water supplies, our airport. You remember years ago, some of you might be too young to remember when you had the millennium mean changing, the whole big thing about Y2K. And everybody thought the world was going to come to an end because you're going to have all these. But it was all seamless because we had prepared for it. We had catered for it, and we were able to deal with it. But the cyber attacks, cyber threats, these are some things we should look at when we talk about the reforms and how we continue to plan for the future. The growth of cloud-based attacks will, of course, increase because increasingly people are storing their information far more economically on the clouds. So it's cheaper, but like everything else, you know how things are hacked. And in fact, it's simple. It's easy to say, I think, that anything that's really you post on the internet is not confidential. It can be accessed one way or the other, either through the webmasters or by hacking. So you have to be careful what you put, or when you put these things, know for sure that nothing is foolproof. These systems are vulnerable regardless of how good they are. People hack into the military, hack into universities, hack into every conceivable thing you can think of. Sorry.
Based on your presentation on the Computer Misuse Act, there are clearly a lot of things which would fall under cybercrime. But we don't in Barbados. We don't see a lot of people charged. Is it that people don't come forward, people don't understand, or is it the mechanism not easy to follow? Because we don't really see many people charged. So do people come forward? Because we talk about blast and inappropriate images and such.
Yeah, well, so far in this country as well as most of the Anglophone Caribbean, you only charge people if there's evidence. So at the end of the day, there'll have to be a complaint. So for example, if you take some of the very salacious websites, for example, people can be charged for that if there are complaints. But even when you have the complaints, as many people would have complained about several things, about a number of websites, you still have to have the information as to who posted it. You have to get the ISP, and you have to get the information of the user and of the users who posted it. Now that is quite accessible also. But you also will have to get technology, input from technology, from the ISPs, how you regulate the ISPs or get court orders against the ISPs. But what you can also do, even if I set up a website and everybody posts on it like a site like Facebook or so, the persons who post those things on it, even if you can't get the owner of the website, you can also charge the persons who posted on those sites. And I'm confident that in a short while, you'll see lots of people being charged for things like that. Because that information can be accessed technically as well as to ascertain who made those posts, and there will be, and I'm sure in a very short while people will be charged for that.
Okay, so that then begs another question: how do you handle multiple jurisdictions? Because obviously, the posting may not have occurred in Barbados, it may have been another jurisdiction. Yeah. How do we handle our act with respect to
once it's published here in Barbados, once it occurs, it can be the website may be hosted on Facebook in the United States or California or wherever. It doesn't matter where it's posted. Once the publication appears here, and the internet is worldwide, it appears here. Once it occurs in our territory, we can charge because we have jurisdiction to charge within the territory of Barbados. Okay? Yes, sir.
Question. I would like to know a little bit about the statistics in terms of what types of cybercrime, because I'm sure that you may see some stuff that come to your desk that you might not be able to act on. Maybe it's incomplete information. You said you gave a little scenario of what is actionable.
Yes.
So my question really is one, what type of cybercrime statistics are you seeing, I guess, from the time that the law was enacted in Parliament to now? And is it been constant, relatively the same? And two, as some of us in here are professionals, what would you like to see us and some of us in here are IT professionals do in relation to helping you in being able to actually get to the root of some of the cases that you would actually like to maybe prosecute and can't do?
Well, I prosecute once there is a breach of the criminal law, and that requires a complainant. But with respect to the volume of cases that we see for prosecutions, largely people complaining about things that will constitute like defamatory in character. People having their private lives published about a sentence of which might be true and 90% might be untrue. You just take something out of context. But most of the complaints relate to personal reputational damage. You understand what I'm saying? You don't. Well, saying that, well, an example would be, let's say you're an accountant in a firm and they say that you're stealing money. That may be grossly untruthful. So at the end of the day, it affects your reputation. So that is the kind of personal reputational damage that's the bulk of the complaints. There are some complaints relating to photographs, but then I think the bulk relates to that, reputational damage. How do we address it? We have to either have, so far the ISPs in this country are largely self-regulated, or if we wish to access who published that, we have to get it through a court order. And even sometimes you get a court order, they still do not comply because they say the posting is overseas. But increasingly, the site is hosted overseas. And for example, we've had a case where people complained formally and through police investigations of postings on a site like Facebook, where an ex-partner, like revenge porn cases then. Yeah. All right, you know what I'm talking about. So you ask Facebook for the information, they take a long time to get back to you, and then they get back to you with something that is almost meaningless, because they have an inherent culture not to comply with governmental authorities' requests. But that is actually changing a bit, because there is a case in England, Nicola, when I get back my screen and tell you it in a minute, who was able to get an injunction because of number. People were just attacking her because she had supported, it's a silly thing, she supported one of the contestants in the X Factor show, which was not a popular decision. And they had all these trolls about the woman on Twitter, and so she was able to go to the High Court in London and got an injunction to say who those order Facebook to release the names of the trolls, and so she was able to sue them. And if it was criminal, I don't know that part. If the Crown Prosecution Service in England pursued it, but it's possible. But with Facebook and Google and some of them, they're like, for example, look at the San Bernardino case, the man who shot a whole lot of people in California. Is it the smartphone people refused to cooperate with the FBI investigation as to how you unlock the phone? Of course, the FBI got it to unlock a different way, and then they asked them, well, how did you do that? Did that? And they said, well, go stuff yourself. So at the end of the day, these things can be ascertained, and increasingly they are being ascertained. And I'm confident in a very short while you will see lots of prosecutions for that kind of troll, that kind of salacious material. And the prosecutions will be available if once there is evidence. Either you can bring them under the Public Order Act for offensive material, you can bring them under the Malicious Prosecution, Malicious Communications Act, or there are several other common law offenses that can be. So let those think who think that they can continue to publish things, salacious or otherwise, about people on the internet. Their day of reckoning is coming, and it's coming really fast. Sorry, more questions, sorry.
I had a question specifically about revenge porn. Revenge porn.
Yes.
I wanted to know what the challenge is there. Why specifically we aren't seeing many more people ending up in before the law courts specifically for revenge porn, because for me personally, I don't tolerate my circle sending me certain kinds of materials. But there's videos that are so shocking to the general public that you hear about them anyway. Videos involving school children in sexual positions, sometimes they're underage. And I want to know what is the challenge there. And much like what Stephen was asking, what can we as a public who are concerned about these kinds of things, especially when children are involved, what we can do to see these kind of acts being publicly stamped out, I guess?
Yes. You see, there isn't a challenge. The only problem is you would see these videos. Has anybody reported it to the police? You see, for the purposes of the criminal law, you must have a complainant generally. And if nobody reports it, let's say the person is a young person, they would hardly report themselves.
Does the complainant have to be the subject of the video?
No.
So if
No.
I saw a video like that, I could be a complainant?
Yes, provided we can prove that the person in the video is a person underage, because if it's an adult, regardless of how, there's a difference with how we treat adult porn and how we treat children porn. Children porn is per se criminal. Adult porn.
So what happens when I get this video on my phone?
I said that because the standards vary. It has to do with standards. I mean, we are not a prudish society. I mean, porn has been a part of almost, you can buy a nude magazine, I'm sure, right? Sorry.
No, but in the cases of child porn, right? Not to get too far from revenge porn, which was my original question, but in the cases of child porn, if I'm in a WhatsApp group and my WhatsApp friends are sending around this video, I have child porn on my phone. When I report it to the police, am I not guilty of an offense?
You're bringing something to the attention of the police. No, you're not aiding and abetting anything if you're reporting it to the police. No.
Okay, great. So in the case of revenge porn now, what's happening? Because anecdotal evidence would suggest that people who are victims of revenge porn are not having a great experience in finding justice. And I think I want to know why that's happening.
I want to know from you if those people have complained to the police, reported the matter to the police.
Yes.
And all right, if they've reported to the police, the police still have to investigate and find evidence to substantiate it. It requires their cooperation also, and many times that is where the cases are stymied, because it doesn't get beyond that, or they invariably change their minds. I mean, look, for example, human trafficking and human smuggling is quite a problem. Many times the police pick up people and charge because they're being exploited. But at the end of the day, the very people who have to testify refuse to do so, and the cases collapse. Because our system still relies on orality. It still relies on viva voce evidence in court. So unless you have those complaints following through and the police can get to the URLs and find out proof of these things, it's just a conjecture, because we do have thresholds of admissibility and reception of evidence to get over to prove our case.
So one last question.
No, that's fine. That's why I'm here.
If I am the victim of one of these crimes, I report it to the police, I'm willing to go to court, I'm willing to testify, I'm willing to do what is asked of me.
Yes.
But I find that I am not getting the response from law enforcement.
Right to
My
the
case,
DPP
I feel
and
like
complain.
right to the DPP and complain. Great, thank you.
I usually send for the files. Yes, any other questions? Sorry.
Hi, my name is David Smith. I have two very quick questions. The first question is, at one point in the past, I remember being told that not to bother to get security cameras for my house because they weren't admissible in court. Is that true or is that false?
False.
Okay, clear. Next question. Is information gained through illegal means, i.e. a hack, admissible in court? Let me give you an example. The Panama Papers, for example, were basically gathered through a hack. The information contained in the Panama Papers brought down quite a few politicians around the world, mostly through political means more so than through legal means. could they be legally used in various countries as for evidentiary purposes, or because of how they were obtained, that wouldn't be allowed?
No, the manner of receipt of the evidence would be subject to judicial discretion as to whether to admit it or not, but on the face of it, it's admissible. So for example, although the evidence is illegally obtained, it can still be used, it's still admissible on the face of it. They will have to show that its prejudicial value exceeds its probative value in order to have it excluded. We are not like the United States in that respect. We accept the fruits of the poison tree. Your first question, I have to add a gloss to it. In as much as the questions with security cameras on home, yes, they're acceptable, admissible, subject to us verifying its authenticity and accuracy. Yes, sir.
Hi, Jason Hines. It's great that you're participating here at IGF Barbados. Thank you.
Him.
Oh, thank you, Rodney. And I couldn't help but think as you were threatening to bring down the law on people, if there's a role for us beyond this forum to engage with our public more, especially our young people, on what is better and acceptable behavior to not abuse the Computer Misuse Act or whatever other crime in their internet activity, and how you think that can be done.
That question requires a multifaceted approach. The law is only one aspect by which you can do that. Other aspects to get the young people to change their thinking or mindset would be public awareness, education, better self-regulation by the internet. It's a wide, multifaceted approach you'll have to use to address the issue. And I think that is why a forum like this is useful, because it brings all these various strands, the stakeholders together, so that we can come up with a cyber security strategy for the country. And that and education and public awareness would be a major component of such a strategy.
So you and law enforcement won't be too disappointed if you have less cases to deal with in this regard? No, we're never disappointed, but trust me, we have far more than we can cope with. Thank you.
My name is Albert Daniels, and this question is coming from one of the hats that I wore in a previous lifetime as an information security auditor and information technology auditor. And it relates to what you've been seeing in terms of the attitudes of some of the victims. We had a case where a managing director of a large corporation was finding that maybe 10, 15 minutes after a confidential board meeting, information that was discussed behind closed doors was being circulated to several people about what had been discussed. So we went in, we investigated, we did, what us IT and security guys do, and we were able to uniquely identify the source of the email, which was a Gmail account. Uh-huh. And we said to the client, well, all you need to do now is get a court order and get Google essentially to release the identity of the person who had been sending these emails. The client, even armed with all of that information, never took it further. So the question is, have you seen instances like that? But what are you seeing generally in terms of the attitude of victims to go the full course in terms of dealing with these issues?
It's a bit of both, because you do have some victims like that who are happy to go, but where the cases get stalled is when we have to send through mutual legal assistance to Facebook or Google or MySpace or somebody like that, ask them for the information. One of the things that can come out of this is if we can get some sort of recommendation as to how we can address this and have a greater cooperation with the ISPs, because they are critical to the enforcement of the law with respect to this. But I did allude to the fact earlier that many of them have this intrinsic culture that law enforcement is anathema to their philosophy, because their philosophy is predicated upon making, advertising and making money. And so they do not cooperate readily with law enforcement. In the European directive, one of the recent EU directives addressed this issue, where they're thinking of imposing very hefty fines on ISPs and providers who fail to take down hateful content, content of people being shot and murdered are put on, children being raped are all put on. That cannot honestly be considered freedom of expression. So we do need the cooperation from the ISPs because they are critical to this entire infrastructure. Oh. No, I think unless you have any more questions, I don't really have to finish this. The presentation is there. I'm actually at my, the very last slide, second to last slide was personal preventative actions, but I was fortunate to attend lunch, and the gentleman who spoke at lunch dealt with many of the things I was going to speak about there. And the conclusions, I would simply say, for internet law in Barbados requires constant education of staff on cybersecurity. Regularly talk to your staff from top management to the bottom. Despite best efforts, a system is only as good as its weakest link. If you're going to click on every icon or everything you see, you're going to get into trouble. And also, you must continue to never make fun of people who raise red flags. Look at them, consider them all, and you invite and you have feedback and ensure that your CERT, your Computer Incident Response Team, is functioning in every organization nationally and even within your home. And when you think now about the Internet of Things, where your television could well be recording you and sending back images of you, you can only be so careful. And I really thank you for having me. It was a delight having you coming here.